something is so that there's absolutely no need for me to even nod in that direction in closing arguments, because almost anything I say would be inappropriate. And so I think it might be helpful for the court to say something.
So, Your Honor, I think I have it.
Listen, if you both prefer that I not say anything, I'm okay, I suppose, doing that. I just wish I hadn't said anything in the first place, that's all. But
I'm in a little bit of a bind because, go ahead.
It's fine, Your Honor. I think the language that we agreed to is based on information provided to the court by the defense. I previously informed you that Mr. Jones intended to testify in the defense case. Mr. Jones has now elected not to do so, as is his right.
how about if I just say the last sentence? Mr. Jones has elected not to testify, as is his right.
He's instructed me, he'd like me to say to the jury, I know I can't, that he's boycotting these proceedings because he feels that he's on the horns of a trilemma. If he testifies in accord with the court's orders, he'll be committing perjury. If he violates the court orders, it's criminal contempt. If he takes the fifth, he gets an adverse inference. And so from Mr. Jones's perspective, by operation of law, he's been placed in an untenable position and has chosen to boycott.
I can't address what his thought process is. I'm not going there. So I'm happy to say Mr. Jones has elected not to testify as of his right, because what I don't want is you to address it when you rest.
I think that makes the most sense because
Okay. So I'm gonna, I can tell them that we're gonna have a shorter day today. I'll tell them that, and then you'll finish up with whatever you have. All right, what else do we have by way of housekeeping? Anything?
in terms of jury management, Judge, you may want to send them home before I make my motion, and without waiving, I can rest in their presence and reserve the right to make my motion thereafter.
You're agreeable to that,
Yes.
so we don't have to have them leave, come back in. That's perfect.
Your Honor, on the ascertainable loss issue, Attorney Pattis indicated we might have an agreement. We have some exhibits that we're planning on putting in, which we would probably use as court exhibits if we had a ruling on that issue. And I don't know that, I mean, I wasn't.
Can we take 5
there
minutes
was
to
an
talk in the
agreement,
hall?
so
You certainly can.
thank you.
Okay,
Sorry.
no
Sir,
problem.
Do you want to recess, or do you want to, because we're still setting up here and.
I'm gonna just stay on the bench because I have my own things to do here, so we'll just, go off the record and stand in recess, I suppose.
Your Honor?
I have a brief oral argument.
Okay, all
and
right, so we are back on the record, and I will hear argument on the ascertainable loss issue. And just give me, now I'll need a minute or two. All right, so we are now on the record, so I'm just gonna ask, that we are quiet in the gallery. All right, who's up first? Doesn't matter to me. Attorney Pattis, do you want to lead? Attorney
No, I'd
Sterling?
rather respond to Attorney Sterling.
Okay,
Your Honor, I'll be brief, because we have already submitted a brief on this issue. So the default resolves ascertainable loss. Ascertainable loss is clearly, under the case law, an element of CUTPA. It's a liability element. It needs to be established before damages can be recovered or before equitable remedy can be recovered. It is a very, very expansive element. The Supreme Court has actually said about ascertainable loss that it's a formless requirement, which they then bound with approximate cause determination. That's the VACO case, Your Honor. So ascertainable loss is established by the default because the default resolves liability in the plaintiff's favor. Then the other thing we briefed, Your Honor, is that ascertainable loss is also effectively decided by the court's ruling in the motion to strike, which addressed almost every element of CUTPA specifically. The defendants didn't move on ascertainable loss, but they moved on proximate cause, on precision of damages, on whether CUTPA covers this count. So the court's ruling on the motion to strike already resolves this issue in our favor as well. And for those reasons, we have tried the case on the belief that ascertainable loss is resolved in the plaintiff's favor as a part of CUTPA liability. So if I may stop there, Your Honor, what we would propose to do if the court rules in our favor on this issue, though, is simply to protect the record, submit some additional affidavits that go to ascertainable loss.
And Judge, we've reached I see Attorney Sterling sitting, I didn't want you to think I cut her off or anything today, and so we've reached an agreement that those affidavits can come in regardless of the ruling. And I don't want to tip my hand too much because this will reflect the directed verdict motion I make, but it's our contention that ascertainable loss as pled in this case, given the pleadings and given the presentation, is vulnerable on appeal, on de novo review, and is susceptible to a directed verdict motion, as I will argue at the close of the plaintiff's case. So while I agree that there is a universe in which ascertainable loss might be regarded as the functional equivalent of nominal damages in the common law counts, I don't think it makes any sense in the facts in this case as pled and as argued. And so I can't agree with the plaintiffs that it's been established in a way that is invulnerable to appellate review, and for that reason I will not agree.
are you looking to respond or no? I don't think it's necessary. So my ruling on the motion on the CUTPA count is the law of the case. But I would say even more importantly, I agree with the plaintiffs that the ascertainable loss is established by the default. All right, so that is my ruling on that. All right, so are we ready for your jury who was again conscientious and on time, or do you need another couple minutes?
Just
Your
1
Honor,
second on
so,
that issue, Your Honor.
Sure.
we will want to mark in the affidavits as court exhibits.
Are they gonna be e-filed by your office?
They
Because
are
that's
right.
the only thing that's gonna hold us up tomorrow for giving the jury the case is
Oh,
if these
of course,
exhibits aren't
Well,
all.
the jury doesn't need these.
No, but I'm gonna have every exhibit e-filed in the case. ID, court exhibits, jury exhibits, we've gotta stay on top of it, so I understand that, but
Yes.
I'm not gonna send it to them until Ron says to me, we're done, because he is in charge of the exhibits.
So we have that issue, which we're taking care of this morning.
Okay.
And then, where are we? Yeah, 1 moment.
Sure.
I'll wait till she almost said the state judge, I guess I betray my, roots as a criminal defense lawyer.
Your Honor, sorry, we're just making sure all the house.
No, that's right. Let's make sure that you're all set so that we iron this out before we bring them out. We're fine.
The other
Attorney
ironing out.
Pattis was actually looking to address the
Oh,
court.
I'm sorry. I
On
didn't
the
see that.
question of the affidavits, I believe there will be 3. I've seen 2 and agreed to them. We discussed a third, and there were going, and I'm assuming, and I thought we reached an agreement on that. I have not yet seen that third. I've now seen the third, so we have an agreement on.
Great.
the affidavit.
Attorney Costco?
Yes, just if I can move to a different issue before the jury gets out, which is life expectancy tables. So typically, in my experience, we've stipulated that as to what the life expectancy tables show. Now, candidly, that's usually in a single plaintiff case or 2 plaintiffs. We have 14 plaintiffs here. So what we would like to do is to have a mechanism by which the jury is simply given what the tables show.
You're talking
Usually-
Attorney Pattis?
We did, and according to my sources, Attorney Pattis is not in agreement to stipulate to what the tables show.
Okay.
I've never had that, but I'm not disparaging Attorney Pattis, that's his right. But typically what counsel does is stipulate that that's what the tables show, but don't say that that's how long. That's not the same thing.
I have to say, I've never encountered it not as a stipulation, so I'm gonna have to figure this out. So,
The reason for, yesterday I was shown a list of their birth dates, everyone's, and I agreed that those could go in. Because if we're gonna have a life expectancy table, we need to know how old they are, no one testified as to their age. This morning, I saw a different exhibit which tabulated this and then had conclusions reached as to the life expectancy under the table. My view of that is, having put no evidence on as to their medical condition or health, that's arguably, they can argue that they're gonna live as long as the table presumes. But I don't wanna be in a position of having agreed to that, because they waived any right to have, they didn't testify as to their health. I have no idea. I mean, a table might say I'm gonna live another 25 years, I could drop dead tomorrow because of the way I eat. And if I'm going to claim to live another 20-some years, I think I've got to sing for my supper, and there was no tune sung in this case, Judge, so I can't agree.
okay.
Well, I think that's just, and I know Attorney Pattis is typically not defending a civil case, so I don't begrudge him that. But typically, I think that's handled by
Well,
the
then
court.
we need a charge on the life
Exactly.
expectancy, which talks about the vagaries and
Yeah.
such. So,
But we-
so I suppose I'm admitting it over objection, but I would deal with it in the standard life expectancy charge that explains exactly what
Understood.
you're talking about, Attorney
And we
Pattis.
can, we do have a proposed charge to that effect, along with the
I'm
ages.
just, why can't I just use the nice
Well,
standard charge?
No, I think that does it for the boilerplate or the foundational, but the court does need to, our argument would be the court needs to plug in the numbers, because.
Why don't you run
over-objection.
past, now that I've ruled, run past with Attorney Pattis what your proposal is? It's the standard charge and you just plug the numbers in?
Yeah, except it has to be done for all the plaintiffs.
Okay,
But it's
so
just
why don't you touch base on that and let me know?
Right now or after?
Well, not right now.
Okay.
As soon as we can get started with the jury, the better. Unless we need more time, and then you can do it now. You're looking for a couple more minutes, or?
Well, I think we're ready, but a couple more minutes never hurts. Whatever you
All right,
want to
do
do,
you want
Judge.
to do the life expectancy now? Do you have something to show Attorney Pattis?
Well, yeah.
Your Honor, this was filed on the 30th, of September. This is the proposed life expectancy chart.
Well, but it doesn't address that this is an estimate independent of any, it simply says this is the normal, like the average normal expectancy, without addressing the fact that it really takes no account of the vagaries of experience.
I thought the standard charge did.
Your Honor, let me pull up the standard chart.
I'm doing it right now.
Thank you.
Here it is. Do you want to come up? I can read it. Would you like
May
me
we
to?
approach Judge?
If you can see the screen, it might be a little better. I'm happy to turn it. Can you see that?
Yes. May I?
You can lean over. Do you want to? Here it is.
Thank you.
Can you see Ellen?
Yes.
You know, the standard charge addresses my concerns.
I'm just a slow reader.
Did they have the word vicissitudes in it?
Damn it. Did I miss that? No.
Oh, good. The old chart, the vicissitudes of life. It's a vicissitude.
We don't have a problem with that, that's fine.
But do just plug it in.
We still have to plug in the plaintiff's numbers, the different plaintiffs.
Testified as to their age and date of birth. A couple of them.
Yeah, and we have a stipulation as to their dates of birth without the date because,
There wasn't much evidence of that. I mean, I suppose their mental conditions was an evidence, so they can consider.
It seems to me that because of the range of things that are to be considered, if the court instructs them on all these factors and they didn't produce evidence on that, that would give me some argument about why life expectancy could be discounted. And that was the thrust of my objection to the.
I understand that,
But-
I do. But
well,
there's
this is-
no requirement that all this evidence be, and they can
Right.
take it or leave it. They may say, we didn't have enough evidence, and we're not gonna.
Well, I think it's fair to alert them to factors that they can consider, and if they've chosen not to put those in, that's on them.
I'm not sure about that. I mean,
Well, we can, why don't you, do you want me to print it out, and you can look at it, but we can tailor it to the evidence that was in, but there was definitely evidence about their mental health,
I mean,
about their occupation.
and permanent-
some of them
and
testified
permanency.
to their exact age, so there's enough, but I agree that,
why don't,
physical conditions.
this would,
Why don't-
imagine just, we can argue later, but just imagine like a rear-end collision case where somebody has a bad back and it's permanent, it goes in, and you don't have a
Nobody ever talks
cardiologist
about
come in
anything
or
else.
or
They may have a bad
oncologist.
back.
Yeah,
They don't. The only evidence in the case is their back.
right.
Nobody talks about
It's similar.
cancer.
Right.
okay.
Hopefully
ruled on
this
the
morning.
exam. Well,
Hopefully we can.
Well, we need it
wrap
for,
up-
we need it in time for the final arguments for sure, but we can,
No, I mean, hopefully we can
After the
wrap up
jury.
the charge.
okay.
You said this afternoon, I'm hoping to be done by then. I'm an
Well,
optimist.
Mr. Ferraro called me and said we plan to be here till 9:00.
I have all these words in the charge, Judge. that
Do you want me to
wanna-
print this out or not?
Yes, please. You good?
Ron, this is gonna, when it says complex lit fourth floor, where does that go?
That's my office,
It is?
yes.
Fourth?
Oh, no, third floor,
Third
sorry.
floor, so that's,
Yeah, and just make sure you go down before you sit, okay? Okay, print on both sides, that's what it's set for. Down at the bottom there.
we don't need this now, so when we get the jury, if you don't mind to, and then when you have time, get it, there's no rush. Thank you very much. All right, so Mr. Farr is gonna get the jury and we'll get ready to go.
use 508. I'm not going to play with him. Oh, yes. During his second. If you agree, then we're good.
Good morning, good morning. Morning, everyone. On yet another rainy day. Good morning. Good morning, good morning. Please be seated. Council will stipulate that the entire panel is present.
Yes.
Yes, Your Honor.
All right, please be seated. So I am so grateful you were all able to make it on time, given the very heavy traffic that we had this morning and the wet roads. And I know we ended up keeping you waiting a little bit, even though you managed to get here on time, but I can tell you, we have been very busy. We already argued a substantive motion. We went through the scheduling for the rest of the trial, and so I can actually share a little of that with you. So we are going to finish the evidence this morning, all right? And then you are going to have the rest of the day off. I can tell you that Mr. Jones has elected not to testify, as is his right. So we will finish the evidence today. We are going to work on your jury charge when you leave today, so we will continue to be putting our noses to the grindstone. And then tomorrow, we will go into counsel's closing arguments. I will then charge you on what the law is, and you will begin your deliberations tomorrow. So tomorrow is going to be a busy day for you, all right? So just for your planning purposes, you will have the afternoon off, and maybe even part of the morning. We'll see how it goes. Okay? They have their notebooks, Mr. Flora? Thank you, sir. Attorney Maddie, whenever you're ready, please.
Thank you. Thank you, Your Honor. Good morning, everybody. So, Your Honor, what we're going to do this morning is just present some exhibits, some remaining exhibits. The first thing I wanted to do, Your Honor, is offer the transcripts of the deposition testimony that we played here. We decided to do that for all of the depositions, not just the ones that might have some audio problems.
Thank you for that. And Attorney Pattis has seen them?
Yes, Attorney Pattis has seen them. And these will be Exhibit 336A, the transcript of David Jones' testimony, 354A, the transcript of Robert Jacobson's testimony, 355A, the transcript of Nico Acosta's testimony, 356A, the transcript of Joshua Owen's testimony, 363A, the transcript of Timothy Fruget's testimony, and 349A, the testimony of Michael Zimmerman.
All right.
All right.
And I just want to mention to the jury that when you begin your deliberations, you will have all the full exhibits with you at that time.
All right, just a few more housekeeping matters, Your Honor. I would also just present to the court, which I understand are going to be court exhibits, the affidavit of Ian Hockley, which is 597, the affidavit of William Aldenberg, which is 598, and the affidavit of Jennifer Hensel, which is 599.
Agreed, Judge.
I have those original. May I approach Attorney
You may.
Ferraro? All right. The next thing we have, Your Honor, is the actuarial table, which is identified as Plaintiff's Exhibit 800, along with Exhibit number 588, which lists the birth years of each of the plaintiffs, and we'd offer those in full.
All right, and that is admitted over objection.
Thank you, Your Honor. Okay. All right. So what I'd like to do now, Your Honor, is present some exhibits for the jury. The first is Exhibit 137. This is agreed to and is an email dated October 29th, 2014 from Nico Acosta to Robert Dew. And if we could, that hasn't been formally offered, but it's admitted, or it's agreed to, and so I'd offer it and I'd ask to publish it.
So ordered. Yes?
Agreed, Judge.
137. Okay. So this is an email from Nico at Infowars to Rob Dew, and the subject is Ebola Sandy Hook crisis actor clips attached. You can just scroll through it. Thank you. I'd also offer, Your Honor, Exhibit 221. This is agreed to, dated March 31st, 2016, a list of radio affiliates carrying the Alex Jones Show.
Agreed, Judge.
So ordered.
And we'll just scroll through this one as well. Thank you. Okay, well, we're halfway through. We'll stop. The jury will have this entire list for them during deliberations. Your Honor, also by agreement, this is, I think the jury has already seen, but we prepared it as an exhibit, Exhibit 278A, relating to sales totals, daily sales over one online retail platform from September 23rd, 2014 to September 29th, 2014. Just display this. We also have Exhibit 397A. This is the cover sheet of the final state's attorney's report concerning the Sandy Hook shooting. We're offering the cover sheet with the date of the report.
And that's a full exhibit by agreement?
Yes, Your Honor.
Yes.
Your Honor, what I'd like to do now is read deposition testimony that is being offered. And I will start with Exhibit 3. $372B. This is deposition testimony of Alex Jones. B. Question. And part of the way that the message that you convey to your audience and have conveyed for the last 20 years is that there's a group of international media, financial, and political elites that are conspiring to establish a global tyrannical government to enslave and ultimately kill people. Answer, yes. What I'd like to do now is go to and Your Honor, in case I didn't do that, I offer that.
No objection.
I'd also offer 370, and we're not going to show this now, I'd also offer 372D, which is testimony of Alex Jones on the same day,
And what was that date?
April 5th, 2022, Your Honor.
Is there an objection to 372D?
It's assuming that this was part of the pretrial designation, none.
It is.
And that's also April 5th, 2022?
Yes, Your Honor. Now moving to Mr. Jones's deposition from April 6, 2022. This is 373A, which I'm offering and I'd like to publish.
No objection, Attorney Patterson.
Assuming it's part of the designation, Judge.
Yes, it is.
All right, so ordered.
You agree with me? Okay. I noticed in your video yesterday that you posted about this deposition that you told, and which you later published on your website, that you told your audience that you are a common man, right? Answer, yes. Question, you said that Connecticut is really a bedroom community for all the richest people in New York. Answer, billionaires and people like Larry Fink and folks who have robbed the country for trillions. Yeah. Question, but you are a common man, right? Answer, yes, I am a common man. Question, where did you fly into from Texas? Answer, I forget the airport. Question, it wasn't Kennedy or LaGuardia or Bradley? Answer, no. Question, did you fly commercial? Answer, no, I flew in a private plane. $373B, Your Honor, which I'd offer also from the same day of Mr. Jones's deposition. This was part of the designated testimony.
So ordered.
Mr. Jones, would it be fair to say that you expect that among the millions of your listeners, many will believe that you are telling them the truth, right? Answer, yes. Question, and sometimes that truth that you tell them is pretty horrifying, correct? Answer, yes. $373C, Your Honor, also from the same deposition, also designated, and I'd offer it.
So ordered.
Question, one of the reasons that you were concerned about your address becoming public is because you were concerned about the potential that people who mean you harm may be able to locate you or your family, correct? Answer, yes. Let's go to the next page, thanks. So you are fearful that people who have that personal information against you could use it to harass you or your family, correct? Answer, yes. People may have a very distorted view of who you are as a result of the way in which you've been portrayed in the media, correct? Answer, yes. If they believe that distorted view, they very well mean you harm, correct? Answer, that could happen. And it's reasonable for you to be concerned about that, both for yourself and your family, correct? Objection, answer, I think it is reasonable. Thank you. .373D, Your Honor. Same deposition, also designated.
So ordered.
Question, you had millions of listeners by the time you were 24, right? Answer, yes. And you were the beginnings of a media empire, right? Answer, yes. Okay. Your Honor, what I intend to do now is play a series of videos, all but one of which were broadcast by Alex Jones during the course of this trial. And I'd like to begin with Exhibit 505, which is a clip from a broadcast of the Alex Jones Show on September 14th, 2022, the second day of trial in this case.
I am so sick of the New World Order. I am so sick of this cult of psychopaths. I am so sick of their lies and their fraud. I don't believe anything they say. And I apologize for nothing I've ever done because I did it all from a place of purity and I've been 98% accurate.
Your Honor, I'd now like to play what have been marked as Exhibit 552A and 552B. These are clips from a video published by Alex Jones on September 23rd, 2022, titled Abomination of Justice. This will be Exhibit 552A.
Once the plaintiffs established that InfoWars played this video, they dramatically introduced an emotional Robbie Parker in the courtroom. Cameras moved in for the close-up, shaking with emotion by the mere presence of Alex Jones.
And now, Your Honor, from the same video, Abomination of Justice, I'd like to play Exhibit 552B.
One of the ways that you encourage your audience to give you money is in cryptocurrency donations, right?
Yes. Infowars.com/crypto.
That will end up as a clip on your show tonight. Your advertisers for your cryptocurrency page.
People care about the First Amendment.
And in the cryptocurrency page, people can give you in Bitcoin, yes?
Yes.
Ethereum, right?
Yes.
As well as XRP, Monero, Litecoin, USD Coin, Dogecoin, and Stellar.
This is it. Get crypto, fund InfoWars. Sponsor us with Bitcoin and other cryptocurrencies.
Thanks to your donations and your support at InfoWarsStore.com, InfoWars is able to broadcast free worldwide, combating the lies of the Great Reset.
Get crypto, fund InfoWars.
Donate now, InfoWars.com/crypto.
Your Honor, I'd now like to play Exhibit 593. This is a clip from the Alex Jones Show broadcast just last week, September 29th, 2022. This is Exhibit 593.
Attorney over there in Connecticut. What an idiot. Oh, well, they've already rigged the jury. It's all rigged.
Now, Your Honor, I'd like to play Exhibit 595. Video published by Alex Jones as part of the Alex Jones Show on September 30th, 2022, also last week.
I mean, you go to Yahoo, you go to Google, you go to Instagram, you go to Facebook, it's Alex Jones at the top, set against dead kids, families for weeks on, never said their names, never even talked about them, all made up. And it's like, oh, my kid died, oh, and Alex Jones caused it, and it's all lie. We're like, oh my God, Jones, you're under some attack. We better not be like you. I'm under attack because I expose these people. I'm just gonna be completely honest. I totally enjoy it. Okay, so I mean, I've reached that point of real peace where I don't just have peace with this, I enjoy it now.
Your Honor, before I get to the last video I want to play that Mr. Jones broadcast last week, I'd like to play what is already in evidence as Exhibit 23A. This is a video that the jury has already seen. It is a video that was published by Alex Jones as part of the Alex Jones Show on January 13th, 2015.
Yeah, when you're trying to decipher cloak and dagger, dirty tricks, it's pretty hard to do. It's just that when you learn that they were funded by Western funding, then you learn that it was the same Amarillo Lockheed Connection underwear bomber. Then those are big red flags that they were patsy provocateurs. The classic MO has been followed. And then, yeah, it kind of becomes a red herring, to say the whole thing was staged. Because they have staged events before. But then you learn the school had been closed and reopened, and you got video of the kids going in circles in and out of the building, and they don't call the rescue choppers for 2 hours, and then they tear the building down and seal it, and they get caught using blue screens, and a email by Bloomberg comes out in a lawsuit where he's telling his people, get ready in the next 24 hours to capitalize on the shooting. Yeah, so Sandy Hook is a synthetic, completely fake, with actors.
So that was 2015. Here is Alex Jones last week on September 29th, 2022. This is Exhibit 594.
But take the Sandy Hook thing. I never really covered that. I covered what people were saying. And then later I said, okay, it happened. But now that I've seen the trials ring and how it all looks, I mean, it's definitely, the whole thing's deep state. That's all I can say. So I think the public's original instinct about it was right. I don't know what really happened there, but it is synthetic as hell.
One moment, Your Honor.
Take your time.
Your Honor, the plaintiff's rest.
Attorney Pattis?
We'll have a motion, Judge, but we intend to produce no evidence.
All right, so the defense rests, and with that, I can send you home for the rest of the day while we get to work on a motion and the jury charge. So, Ron will collect your notebooks, but I have to say, I know that you have obediently followed the rules and that you're a conscientious jury, you're always on time and so attentive to a fault, but we are so close to the finish line now that it becomes more important than ever that you insulate yourselves from any media coverage, that you continue not to do any research, that you not have any discussions with each other or anyone else about anything that's happened in the courtroom, even though the evidence is done, that doesn't mean that even any of you can speak to each other. You will know, because I will tell you clear as a bell when you can begin discussing anything that happened in this courtroom. And even then, you will only be able to discuss the case when you are all together and only when you are in the jury deliberating room, all right? So even then, it's very strict. So with that, I'm gonna thank you very much for your traveling here for a short day of evidence in the bad weather. Take your time going home, because I know the roads are wet and might be a little slippery. We will start tomorrow at 10. As I said, it will be a full day. And we thank you as always for your patience and for your attention. All right, so you'll follow Ron out and I will stay on the bench. Whenever you're ready, Attorney Pattis.
So I'm making a motion in the alternative for a directed verdict or a motion to dismiss. And I guess I'll start with the directed verdict. There are three grounds, Judge, for these motions. First is a lack of standing. Second, because of the misapplication of CUTPA, in this case, or an attempt to evoke CUTPA where CUTPA doesn't lie. Second, the failure to plead a necessary element in the complaint of ascertainable loss. And third, the presentation of the failure to present evidence that would support the verdict. And I make these motions in the face of and acknowledging the power of the default and with knowledge of the prior motion to strike, because our appellate courts have held that with respect to standing, that can be raised at any time, even in the presence of a default, that the appellate standard for review of a verdict in a CUTPA claim, even in the presence of a default, is de novo. And that suggests to me the trial court has the responsibility to evaluate purely legal claims at the close of the plaintiff's evidence. The evidence as presented in the representations of counsel thus far have been that they are seeking, with respect to the common law claims, only emotional distress. And that's all they're seeking. If you look at the manner in which the complaint was pled, Judge, the CUTPA claim is the fourth of the last of the viable counts. The negligent infliction count was withdrawn at some point. And that incorporates by reference the various pleadings that preceded it in the complaint. So, for example, in the common law complaints at paragraph 419, 432, and 446, the plaintiffs pled actual and substantial damages. And that's what they've reincorporated into the CUTPA count. Our Supreme Court is clear that emotional distress alone is insufficient to support a CUTPA claim. And I rely on Parnoff versus Aquarian Water Company at 188 Connecticut, Conap 153, a 2019 decision, as well as DiTeresi versus Stanford Health 149 Conap 502 2014. So the first motion is that as presented, there simply is insufficient evidence for.
Can I ask you a question, Attorney Pattis?
Yes.
So the CUTPA count incorporates the prior paragraphs which claim the emotional distress, but then the last paragraph adds the claim of damage. It's not limited to emotional distress. What say you about that?
The representations of counsel is they're seeking solely emotional distress here. There is no claim for economic damages, and thus the case as presented is going to be presented to the jury as a pure emotional distress claim, and that's insufficient as a matter of law for CUTPA. That's my claim. The ascertainable economic loss, the second claim, is as pleaded, And again, the appellate court takes a look at the pleadings to determine, even in the case of a default, whether it's adequately pled. Under Ritchie versus Main Street at 110 Con Ave 209, we conduct a plenary review of the pleadings to determine whether they are sufficient to establish a cause of action upon default. It is our contention that they are not, because what the plaintiffs claimed was actual and emotional loss without ever claiming actual and substantial damages without ever pleading ascertainable loss. I'm not trying to impose a magic word test on the pleadings. I understand that the plaintiffs are entitled to every reasonable inference, especially in the context of a motion for a directed verdict. But it's our contention that they've abandoned their responsibility to show ascertainable economic loss. Most substantially, though, we claim that this is a novel application and frankly a terrifying application of CUTPA, because this is an instance in which there is no representation whatsoever that the plaintiffs were harmed in any respect by Mr. Jones's commercial activities with respect to the sale of dietary supplements. So with respect to Soto v. Bushmaster, which the plaintiffs may claim opens the door, in Soto, unscrupulous advertising was used to sell military-grade weapons to a civilian. And the courts ultimately concluded that that was sufficient to support a CUTPA claim, even in the absence of a commercial relationship, because those unscrupulous ads placed into the hands of Adam Lanza a weapon that he used to slaughter people. There's nothing analogous to that in this case. Mr. Jones didn't oversell hair growth or follicle material or iodine to anyone. There's no evidence that anyone was harmed by his commercial activity. The court and the jury may conclude that Mr. Jones's speech acts were odious, and that's what defamation and defamation per se addresses. They may conclude that his speech inspired others to harass and intimidate these people, and I presume that falls under the intentional infliction of emotional distress. They may conclude that his verbal and written activities placed these plaintiffs in false light to their economic harm and detriment, but nothing in that speech or the consequences of that speech addresses what CUTPA is intended to address, or what Soto v. Bushmaster addressed, and that is whether consumers were harmed by the commercial activity affecting trade or commerce. If someone had gone out and bought a gross of these pills and thrown them at someone and hurt them, that might be an argument, assuming the ad encouraged people to do that. But what we have here is a novel attempt to use CUTPA to silence unpopular speech. And the purpose is plain. The purpose was announced in opening statements, which I realize is not evidence, but this is legal argument. The purpose of this litigation is to silence Alex Jones. And the only way they're going to be able to do that is with an enormous punitive damage award, which this court has discretion to award under CUTPA. The punitive damages will be limited in the common law claims to attorney's fees, and I'm sure they'll be significant, but they won't be significant enough to cripple Mr. Jones. So we think that CUTPA is being used for inappropriate grounds, and that the plaintiffs lack standing to bring the action because they cannot establish that they were harmed by Mr. Jones's commercial activity. As I understand the plaintiff's case, there's a strong and a weak CUTPA claim implicit within it. The strong claim is that they pay attention by way of Google Analytics and other analytics to spikes within their web traffic. Thus, when Mr. Jones speaks about Sandy Hook, it spikes. Let's talk more about it because it'll drive people to our site. The weaker claim is that by peddling fear, Mr. Jones is able to capitalize on that fear and inspire people to buy products. That might be an unscrupulous ad if a person affected by those products could come forward and say, I would never have bought it had I not been inspired by his fear. But that's not the claim here. What we have are three torts that will go to the jury, and my motion is not directed to those torts, Judge. I will concede that the evidence, if credited, is sufficient to warrant a judgment against Jones. As to the CUTPA claim, there's no case that supports what the plaintiffs intend to do in this case, and that is use a statute that is designed to protect consumers against unscrupulous trade and commercial practices to attack speech. And that makes this case terrifying from a free speech perspective. And we urge the court to strike this claim or to grant our motion, because nothing in our law supports an application of cutba on the facts as pled and proven in this case.
Thank you. Attorney Sterling.
Yes, Your Honor.
And one last thing. May I submit I've got a typographically written motion that I'd like to tidy up and submit as part of this record later in the day.
How do you want me to handle it, and just wait for that before I rule?
No, I can give it to you now, but I'd like to submit it, I'd like to submit it to cleaned up version.
Has plaintiff seen it yet?
I'm giving it
No,
to you
Your
now.
Honor.
How long
I've
is
not
it?
seen it yet.
8 pages.
So,
Well, I wanted to wait until the close of the case, as is customary.
No, I understand, but I don't, if you're gonna file it and after she's argued, how does she respond?
If she wants to take a moment to read it, she may, but it won't say anything that
I'm
I
happy, why don't we try to do that and see if we're able to read? Do you mind, Attorney Sterling? We can try and see if.
Your Honor, if we're going to do that, what I would ask is that I have an opportunity to read it, make some notes, and then I'll respond. Given
Not,
this 8 pages.
not unreasonable. Do you have a bench copy?
I do.
Would you mind giving it to me? I sent Attorney,
May I approach?
you may, Attorney Ferraro to start working on the exhibit so that we can hopefully not have a delay tomorrow. I thank you. And is your office also going to e-file it?
Yes.
Thank you. All right, so then why don't we hold off on the rest of the argument? Can we start to get to work on the jury charge?
We can do that, Your Honor. The only thing is yeah, we want to defer argument for a little while on this and turn to the jury charge and then
All right,
take a
so do
break.
you
I'll
want to take
prepare
the
myself
morning
for a
recess
second.
now? We'll pick it up at 11:30, finish the argument, and then can we get to work on the jury charge?
Yes.
Okay.
Your Honor, I understand Attorney Ferraro's not here. He raised with our team, I think yesterday, that one of the videos that we offered and played last week, it wasn't clear in the record what the number was. It's Exhibit 508. He asked me to confer with Attorney Pattis. We have. Attorney Pattis agrees that that's what it was. So I just wanted to make that clear for the record, and we can let him know later. But
Maybe you can go get a cup of coffee during our
I'll let
morning
him know.
recess and let them know that it's 5:08.
Yep,
when you're
thank
filling
you.
your
That's
cup.
all I
All
have.
right, so then why don't we plan on coming back at 11:30? We'll pick up the argument, and then we'll turn to the jury charge, okay?
Yes.
All right.
Thank you.
rise. Courthouse stands at a 1-minute morning recess.
Speaking of that, the video is filed, do you think?
You're off the record, correct?
Yes.
3 weeks in this trial, we have heard a description of massive damages, massive injuries to these plaintiffs, which is exactly what the allegations of the complaint foretold. And to hear that evidence described as merely emotional distress is both par for the course in this case and par for Alex Jones's approach. But it ignores the evidence, it ignores the truth, and it ignores the law. And so as I understand, the motion for directed verdict is attacking the CUTPA count alone. Our CUTPA law says that this is exactly the kind of case that comes under CUTPA. If these plaintiffs don't have the right to bring a CUTPA case against Alex Jones after everything he has done to them, then who does? And so they have CUTPA standing under Soto versus Bushmaster, but also under the plain language of the statute. Any person who suffers any ascertainable loss is entitled to bring a lawsuit. The court has already found proximate cause in the context of the default. That is the sine qua non of CUTPA standing. So that's resolved. The court has resolved ascertainable loss. These issues have been decided. In terms of the notion that this case is only about emotional distress, again, that profoundly misunderstands and misstates the evidence. The evidence is that there are 550 million impressions of lies by Alex Jones, and that is reputational injury in addition to causing emotional distress. Not only that, that's measurable in the sense of ascertainable loss, and it is catastrophic. And so to hear that minimized, again, it's just, it is understandable that what Mr. Jones would like is for these families not to have standing to hold him accountable, but it cannot be under our law. With regard to the reference to the DiTeresi and Parnoff cases, I think counsel misspoke and indicated that those are Supreme Court cases. Those are not. Those are appellate court cases, and they're pre-Soto cases. It's our position in this case that the reputational harm gives rise to the CUTPA claim as an encompassed within the CUTPA claim, and also that emotional distress damages are encompassed within the CUTPA claim under the circumstances of the case. So that to the extent that, and I don't actually think, Your Honor, that is in conflict with DiTeresi, because DiTeresi's approach on emotional distress says, well, it's not measurable. And that's the rationale for not including emotional distress as a predicate for CUTPA. Here, we have both the determination that severe emotional distress already exists as a result of intentional infliction, and also there is the measurability of the reputational harm, which goes to emotional distress, although also independently damages the plaintiff's reputations. So, and Your Honor, I am putting that on the record because I want our higher courts to be aware that that is our position. Let's see. With regard to the idea that the CUTPA claim is only about statements, it's not. What it describes is a commercial course of conduct that is built on targeting and victimizing these families
by lying about them. So certainly lies are in the mix, but what the court heard was not just the occasional lie. It's the use of lies to sell products, to fuel a business. That is what Mr. Watt's testimony was about. That's what the testimony about social media analytics and Google Analytics is about. There is a business plan to hurt these families and to sell things by hurting them. And that has to be remediable under CUTPA. It has to be. There were some references to the complaint, Your Honor. The CUTPA count is pleaded last, and it incorporates all the prior allegations. And there were some representations by counsel that my clients are only claiming emotional distress. That is inaccurate. My clients are claiming reputational damages and emotional distress. Excuse me?
Sorry,
Yes, and invasion of privacy. So I just don't understand the source of those representations. The reputational harm includes all the evidence that the court has heard, which has included evidence of economic loss. We're not seeking to recover those damages, but that is all in the case. And certainly evidence of ascertainable loss has come in repeatedly in the case, even though it's already established by the default. One of the grounds for the motion, Your Honor, was that the complaint fails to state a claim for ascertainable loss. We've already covered that this morning, so I won't address that. So I think where I conclude, Your Honor, is there is absolutely a CUTPA claim that needs to be presented to the jury and will be also for decision by the court. And the motion for directed verdict must be denied.
Attorney Pattis?
I guess I should get used to even polite ad hominem attacks. They are the course in this case. I won't respond in kind, other than to say that counsel's argument is long in emotion, short on analysis of facts, and vacant as to law. There is no CUTPA case that says a person who engages in speech, even in extreme speech, can be held liable under CUTPA. We don't concede, we don't contest at the directed verdict stage defamation. We don't contest intentional infliction. We don't contest breach of privacy. Those cases will go to the jury. We're not arguing that it's statements alone. I conceded in my opening statements, as I do now, that under the default law, the harassment and intimidation by unnamed and unknown persons are attributable to Alex. That's fine. I get that. But what CUTPA sounds in it, it's not enough to come in here and say it can, it must, it has to be. The argument has to conform to the requirements of law, and there is nothing in Soto v. Bushmaster that says that if a person engages in extreme comments and relies on the sale of products to produce that platform, there's nothing that says absent the plaintiffs being affected by those products that CUTPA is applicable. The reason we have a broad medley of torts in this country is to permit people choices of remedies so that they can recover for the harm they've experienced. The harm that these folks have experienced in terms of defamation, intentional infliction, and breach of privacy is compensable, and they can get what the jury will award them. What they can't do is transform CUTPA into an attack on speech.
All right, so the lack of standing raises subject matter jurisdiction, and I must rule on that now. So the motion to dismiss on the standing issue is denied. The motion as it relates to ascertainable loss is also denied, as I ruled on that earlier, and I will reserve decision on the remaining issue. Ron, can you give the council copies of the life expectancy table that I was able to print out? Thank you. All right, so can we
Your Honor,
turn?
may I inquire on one issue? So the court is reserving decision on the
I just
whether.
routinely reserve decisions on all motions for directed verdict, and I would have entirely reserved here and just dealt with it later. But because it raises standing, which is subject matter jurisdiction, I need to rule on that. The ascertainable loss I already ruled on, so I'm denying the motion as it relates to that, and I'm kicking the can, as I always do, on the rest of the directed verdict, because that's.
So, Your Honor, in that event, I think maybe we'd like to submit a brief on the non-standing issues.
Sure, I don't see why not.
Okay, thank you.
Okay.
I should say maybe we may want to.
All right, so we're ready to go on the charge?
Yes.
Yes. I just need 1 second to clear away
Sure.
these papers. Oh, yeah, Attorney Koskow's going to start with life expectancy, if that's all right, Your Honor.
Well, I wanted you to talk to Attorney Pattis about it first,
Okay,
if you don't
so we'll
mind.
do that at the break, Judge, or do you want to just do that right now? We got a
Whatever
lot
you
of
want, it doesn't
housekeeping.
matter to me.
Maybe you guys want to do, well, it's up to you.
While attorney, I think I have a short one. While Attorney Sterling is getting organized here, I want to talk about how long we're going to have for closing. I know Attorney Pattis has requested an hour. We request 2, which would be inclusive of summation and rebuttal, 15 plaintiffs, 4 weeks of trial. I understand that Attorney Pattis wouldn't consent to that, and so we just wanted to have some clarity from the court on what we'd be allowed to do.
Attorney Pattis, do you want to respond?
Yes, I think in opening, the position was better at forced concision, although it's been a 12-day trial, maybe we've had 12 days for partial evidence, and 15 plaintiffs, the plaintiffs are all similarly situated, and there's nothing that distinguishes them one from another. And my view, Mr. Richmond and Ms. Hensel may have claims that are just different in kind, but everyone else more or less looks the same. And I don't see the need for more than an hour, and so I would request the hour.
I disagree, so both sides can have 2 hours.
It's just,
Okay. Do you want to?
Well, I didn't want to get us off track.
Why don't you and
Because
Attorney
I
Pattis?
could look at this, Judge, actually, excuse me, sorry, Judge.
No, that's right. Do you want to do it together now, or do you want to wait?
Why don't I look at there's some things I just need to correct, because this is for a case where there is a liability issue, so let me just make some corrections while you guys are,
And you'll
and
give it.
I'll show it to Attorney Pattis.
Okay. Okay, give me 1 moment to get situated. One thing that we left off on yesterday, and I've got a list here that I'd like to start crossing off, was the plaintiffs were considering proposing new language about Alex Jones and free speech systems.
Yes, Your Honor, good news. In the new charge that Your Honor has a copy of, we did propose new language, and that was acceptable to the defendants.
What page is that on?
That is on page 7 in red.
May I have a moment, Judge?
Please.
There is an agreement on that language, Judge.
Okay, so I can cross that off the list.
Yes. Your Honor, on that charge, though, I just think that we should look at the top part of the charge then and make sure that it's not confusing in relation to that instruction.
I don't understand what Attorney Sterling is referring to as top part of the charge.
So the top part of the charge, corporation or other entity as party, which is on page 6. Your Honor, I think that's quite confusing, given the instruction that Mr. Jones and Free Speech Systems are each legally responsible for the other's conduct.
Well, except that one of the parties nonetheless is an LLC, so there's nothing wrong with saying you must treat all parties in an equal and unbiased fashion, right?
No, I think that's fine.
So why don't we take out the sentence under corporation or other entity as party? Take out the verbiage, rather you must assess the claims and defenses of all parties without regard to their, and just put in, you must treat all parties in an equal and unbiased fashion. So that would be, you have heard that one of the parties in this lawsuit is the defendant Free Speech Systems LLC, which is an entity created by the law. All parties are equal before the law. The mere fact that one of the parties is, I don't know if we want to say one of the defendants, but one of the parties is a natural person and one is a creation of the law should not play any part in your deliberations. You must treat all parties in an equal and unbiased fashion. That's not objectionable. That's neutral.
I take no position on this. I think it's fine as is, and the court's suggestion is fine. I don't think there's anything confusing about it.
Your Honor, I think that's a significant improvement. I
All
appreciate
right,
it.
so
Thank you.
you'll delete, rather you must assess the claims and defenses of all parties without regard to their, and insert you must.
You must.
Okay.
Got it.
What about the implicit bias charge?
I can't agree with it. I can't agree to it, Judge. I mean, the basis is that somehow using cool reflects some sort of bias or is a microaggression against some unnamed group. I mean, the language is all we have left. And to start making claims like that about language, to talk about cool and dispassionate, I don't want to go down that rabbit.
We're urged to use the implicit bias charge in all our cases, civil, criminal.
This arose with respect to the claim that cool was somehow culturally.
But Attorney Sterling wasn't even sure she was going to want it anyway, so before you start arguing against it, let's see what her position was.
So my position, Your Honor, is as I am delinquent, I need an opportunity to look at it.
Well, this
I
is
will
the
do
time.
that. Okay, then we're not claiming it.
There we go. Okay, we're moving along. All right, where are we next? What's the next issue? Should I go back to what I had to do, my homework from yesterday, or do you?
Yes, that would be most helpful.
Okay. So correct me if I'm wrong. The first thing that I was supposed to look at was on page, well, I don't know if there's a new page number now, so let me look. Under causes of action?
Yes, that's what I have, Your Honor, the
Okay.
nominal damages.
Right, and I think that I have, I'm going to delete the only if the plaintiffs can prove damages are they entitled to more than a nominal sum, because it's covered plenty of times in other places.
I'm not sure that exact language is covered anywhere. I think it's important for this jury to know that that's the starting point.
Well, so let me see, just bear with me. So, under damages compensatory, we have, in order to recover more than nominal damages, the plaintiffs have the burden of proving their entitlement to recover damages by a fair preponderance of the evidence. Then we also have nominal damages. Let me see where it is. I marked a couple other places, but just bear with me. Paid under damages for libel and slander per se. So it is gonna be what it is gonna be, so.
Yeah, I understand, Judge, I just
Okay.
wanted to note my objection.
Yep. All right, so then I have under defamation, is that where we? That
Would be page 17, Judge?
Well,
Yes.
I'm looking at yesterday's document, honestly, because that's where I made all my notes. So I thought there was something for me to do under defamation.
No, we actually, we resolved that yesterday, Your Honor.
I
Okay,
think that's what I got, Judge, that we had.
okay. Then proximate cause,
That was a place where the court was gonna make a
I
decision.
did, and just bear with me for 1 second.
May I speak to Attorney Manning for a moment?
Please.
It's my view, I'm thinking, I wish I had somebody hear that.
All right, I had no problem with any of the plaintiff's proposed changes under proximate cause. I thought it was helpful language, actually.
Okay, so for my work as a scrivener, Your Honor, I will
Which I'm
accept
leaving to
those
you.
changes.
And I'll just recite my objection on the grounds that it comes perilously close to transforming proximate cause into but-for causation. And I understand you've ruled, Judge.
Okay, so the next area I believe I have is standard of proof damages.
Yes, Your Honor, the continuing objection on our part as to nominal.
All right, so just bear with me. So I am going to delete the first sentence then I'm gonna change it. The sentence that says because, the first two sentences, I'm gonna delete. And what I intend on saying is the following. Although the court has already determined that the defendants are liable to the plaintiffs, I must still instruct you as to the burden of proof in a civil case such as this. And then go on to, you may have heard in criminal cases that proof must be beyond a reasonable doubt. I can't see how that's objectionable. They need to know what the burden of proof is.
Are you deleting in order for you to award more than nominal damages?
Yes,
I object. That's
okay.
second deletion of that concept.
All right, well, this is the standard of proof. Anything from the plaintiff?
Your Honor, if could the court just recite that language again? Just want to make sure I have it.
Although the court has already determined that the defendants are liable to the plaintiffs, I must still instruct you as to the burden of proof in a civil case such as this, period. And then it goes on, you may have heard in criminal cases.
Thank you.
All right, the next thing I had is under, and if I'm skipping something, you have to let me know. Damages compensatory?
Yes,
Okay.
and there we have the nominal issue again.
So let me address the did we, the list of, so I think we all agreed that wrongdoing instead of negligence already, right?
Correct.
Yes,
And injury, we're gonna use harm.
Correct.
yes.
Okay.
And Your Honor, I
Right.
intended to make those changes globally. Oop, I missed one.
All right. So I think we've talked about the whole issue of nominal damages, whether they're appropriate, given some of the claims. And I've looked at the case law as best as I can, and I think what the plaintiffs are arguing is that in a defamation per se case, nominal damages are precluded. That's what I hear. Am I understanding that right? And that there's some kind of, I don't know, default or assumption.
No, Your Honor, the first argument actually goes to the emotional distress damages.
Well, it's the same sort of argument though, isn't it?
Well, I think it's actually even clearer and stronger as to emotional distress, because the court is charging, I mean, the court heard my argument yesterday.
I did.
And so, it's inconsistent to say that there's severe emotional distress. The court understands the
I
argument.
do, and I'm gonna not rule in your favor on that. I don't think that that nominal damages are precluded on these, in this situation, so. What do we
Okay.
need to do here under damages compensatory?
So Your Honor, we'll stand on our objection there, of course.
Yes, absolutely.
I'm not sure there's anything more to do.
I'm just triple checking to make sure. Are we otherwise, set on this section?
I have red lines, and I agree with the red lines. I don't recall talking about those yesterday. Eliminating pain and suffering, for example.
Yes, we did agree to that.
Yes, we did. Your Honor, I'm sorry, is the court just accepting that in order to recover more than nominal damages, the plaintiffs have the burden? Was the court proposing a revision there?
Give me one moment. I'm not sure. So we can try to work on different language to make sure we're stating it right. So so what about this language? The plaintiff's burden, this is.
Which page are we on?
Well, we're under damages compensatory, and I think plaintiffs had an issue, if I'm not getting it wrong, second paragraph that says, in order to recover more than nominal damages, the plaintiffs have the burden of proving their entitlement to recover damages by a fair preponderance of the evidence. Am I on the right sentence?
Yes, Your Honor.
All right, so if I lift the language exactly from an appellate court, from the Murray versus Taylor case, I'll read a sentence from it and tell me if we can make this more accurate or more palatable. The liability of a defaulted defendant is established, and the plaintiff's burden at a hearing in damages is limited to proving that the amount of damages or harm, or whatever you want to call it, the amount of damages claimed is derived from the injuries or harm suffered and is properly supported by the evidence. So that's, you want me to read it again?
Yes, thank you.
All right. The liability of a defaulted defendant is established, and the plaintiff's burden at a hearing in damages is limited to proving that the amount of damages claimed is derived from the injuries suffered and is properly supported by the evidence. That's the language Murray versus Taylor lifted from Ratner versus Willamette. So,
And Your Honor, the idea would be to take out that.
well, I think it's probably, I think we're safer if we lift the language and quote it directly.
I'm not seeing what we're lifting. I'm not following.
I think the issue of what do the plaintiffs
No, I
need.
mean, I'm not seeing
Oh.
it I'm on,
Under damages compensatory, there's the first paragraph that starts the rule of damages as follows, and then, I guess it is still the first paragraph, I'm sorry.
that's what threw me. I don't see.
I'm sorry, yep, it's the first paragraph. That's a long paragraph.
Yeah.
Maybe around 5 sentences down, and it starts with, in order to recover more than nominal damages.
No, I think if you want to add the Murray language, fine, but I believe that this is the third instance where we're just diluting the import of the nominal damage instruction. Yeah, so I wouldn't
Well-
object to adding Murray after that sentence.
Well, it
because-
is, you're right, Attorney Pettis, it does not use the word nominal damages, and I think this would be the appropriate pace to put it in, so I agree with you on that. So let me look at it and.
Your Honor, if I may, this had also implicated defamation per se, and the court had a question there.
I'm sorry?
Sure. So with regard to the nominal damages issue, the court began with a question about our position on defamation per se. And I'll repeat that position from yesterday, which is that nominal damages in that instance could only be appropriate in the way that's described by the charge, which is that the plaintiff gets set back by all of these aspects of the evidence like that.
I understand your position, I just don't.
Thank you for hearing me,
disagree with
Judge.
it, though, yeah, okay. So,
Your Honor, may I be excused for a few minutes?
certainly. So how about this language? In order to recover more than nominal damages, the plaintiffs have the burden of proving that the amount of damages claimed is derived from the harm suffered and is properly supported by the evidence.
No objection.
I mean, that is, we can't get any more accurate under the law.
So, I apologize, Your Honor, but would you mind
Yeah, no
giving it to
problem.
me one more time so
Sure,
I
sure.
can see what's in
I'm so
it?
happy that you're gonna be doing it, that I'll repeat it 10 times for you if you want.
Well,
'cause
I
am-
hope so then we really need to make sure that I've
Yeah.
got it right. So if we started, our
it-
laws impose certain rules to govern the award of damages in any case where liability is proven.
In order to recover more than nominal damages, the plaintiffs have the burden of proving that the amount of damages claimed is derived from the, we're gonna say harm instead of injuries, right? Harm suffered and is properly supported by the evidence. Because that language, the amount of damages claimed is derived from the injuries suffered and is properly supported by the evidence, is long-established case law.
Could we include is derived from the harm suffered as I have described it to you and is properly supported by the evidence?
I don't think so. I mean, unless you're agreeable to that, Attorney Pattis. I'll do it if it,
I thought the charge as stated was fine. I thought that the next one was fine. It seems to be done. No, I don't agree because I think the court has indicated what it wants to do and
yeah, I think it's
arguing
clear
at the margins.
and it's an accurate recitation of the law, so I think that's where we'll leave it.
Okay, we'll stand on our
understand.
exception, Your Honor.
Okay. So I think, and again, you have to tell me if I missed something.
In
We are-
damages for
Yes.
invasion of privacy
Oh.
and emotional distress, I made a mistake, Judge. I did not take out the non-testifying plaintiff, so I'll take that out in the next
Okay.
round.
So my next item, I think, was under damages for libel and slander per se.
Correct.
And I think the only issue that was left was near the end, if I'm not mistaken, and tell me if I'm wrong, near the end that says, if on the other hand you find that the defamatory material is of significant character, that language?
Yes.
All right, where did that language very substantial damages come from. That was interesting.
Yeah,
I was very interested by that. I couldn't find it in any case law anywhere, but
I think the Koskoff brief bank could.
The case of Koskoff v. Sterling.
I'm going to attribute that to Attorney Koskoff, Your Honor.
The very, but not the substantial.
all right, so obviously.
No,
the very-
actually, the substantial is in the case law.
Oh, I know that, but I
yes,
never,
but
I'm
the
familiar
very,
with that.
the very is,
The
So I
very,
don't get my very?
it doesn't exist.
you know, he's going to blame me for that.
Give you A for effort, though. So Attorney Pattis, what is your, taking out the very, what is your issue there? Because I don't see an issue, but I could be missing an issue.
Yeah, I didn't see the need to depart from the standard charge. Yeah, you know, it struck me that this was reflecting the argument that wanted to be made at closing, which is fine, but I didn't see any deficiency in the standard charge.
All right, okay, so I actually, I try to look at it from the perspective of the juror, giving them
Right.
guidance. I liked it, I thought it actually clarified things, so I will include it.
You note our objection.
Absolutely. Okay, so I think that gets us up to new ground, correct? No?
There's a tail end of that charge, Your Honor. So,
What am I looking at?
on page, well, let's see. After the new language about you may award substantial damages,
Okay.
the language we just added,
Mm-hmm.
there's a sentence, nominal damages are also awarded when they are the only damages claimed and the action is brought for the purpose of vindicating the plaintiff's character by a jury verdict that establishes the defamatory material was false. That just doesn't fit this case.
No, it does not.
It doesn't, I'll agree with that.
Okay, so that's.
So that
approved.
comes out. And then, the summary language,
I thought it was confusing.
I think it is because we're not claiming specials.
So can you and Attorney Pattis maybe put your heads together if you want summary language? Because I do,
Your Honor, I don't think we need it at all. I'll certainly discuss with Attorney Pattis if he feels that we
If we want to
do.
leave in at a minimum, each plaintiff should receive a small amount of at least $1. I'll agree to eliminate just two preceding sentences if that sentence remains.
No, we can't agree to that.
Then you probably should decide, Judge, because I give up. This is, you know.
I actually think, Your Honor, I think we should keep the language about you may award punitive damages as a matter of discretion. I think that needs to be in there.
all right, so I thought the summary was just a little confusing, but do we want to put some less confusing summary in? I'm okay with leaving that you may award punitive damages as a matter of discretion, and at a minimum, each plaintiff should receive a small amount of nominal
You
damages.
can eliminate the summary sentence in my view, Judge.
We don't need it?
Correct.
Okay, but we do have an issue with
I understand.
should receive a small amount of nominal damages of at least $1.
I'm not wed to that exact language, but I think that we need to include the nominal damages somewhere here.
I think this states it precisely. At a
Well, we
minimum.
do have earlier in the charge, nominal damages of $1 may be awarded. Then we talk about substantial damage. So we do earlier in the charge talk about nominal damages.
Your Honor, I'm just looking back up
A lot.
that this is the
Well, we've
nominal.
eliminated several, so don't say a lot, Judge.
Well, look at the earlier part of the charge, we talk about nominal
But we
damages.
revisit compensatory damages because there are special considerations with respect to defamation. And if we're gonna revisit compensatory damages, I think we need to revisit the anchor, and the anchor is nominal damages.
No, I mean, Your Honor, if it just ended with you may award punitive damages as a matter of discretion, that would be.
That would be great.
Yeah, wouldn't it be? Maybe,
Well,
maybe say, maybe.
And it
change
wouldn't be long-winded.
May to should, you know?
Well, but can I, we say, so, just bear with me, at the beginning of the charge, right, damages for libel and slander per se, just bear with me. So we talk about, we have the sentence, if you find the plaintiff has suffered blah, 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 he or she is entitled to at least nominal damages. Then we say nominal damages may be awarded because you find the defamatory material is insignificant, blah, blah, blah. Then we also say nominal damages are also awarded when they are the only damages claim.
But we took
Oh,
that
no,
out.
we took that
Oh,
out.
am I looking at the wrong version?
But we,
No, we just
I
discussed.
think I have the same page twice.
Well, it is confusing here. So
I'm gonna leave the last two sentences in for now, and as soon as you can get me a clean copy and I can eyeball it, and I'll leave the door open to address it again
Thank
on
you.
both those sentences.
Thank you,
Okay?
Judge.
There's so many strikeouts now, and I'm working off a different version. I don't wanna say it 8 times, but I sure don't wanna not miss it, so, and not say it. All right, so
Understood.
now we're up to CUTPA, correct?
Yes.
Okay, and that's where we left off, no?
I don't recall.
I don't know that we,
I think you've decided the ascertainable economic loss
yes,
thing.
but I mean, we haven't
Right.
talked about the charge
We
Um,
haven't.
specifically, so tell me what we need to do under, what's the first thing I need to decide?
Well, we had asked that the court extend its charge on ascertainable loss, given the defendant's argument, and so I would ask that the court do that. So that is, we're asking that the court charge on it as an element of liability, that it's been found.
So what is
I don't think it's necessary, Judge.
No, I don't think it's necessary either at this point. The court's ruled, I've got it preserved.
Okay.
All right.
Yep, that's fine.
Okay, so is there anything I have to address under CUTPA?
Your Honor, just for the record, I'm not thinking that because we're not asking, at least in my conception of the way the verdict form would go, and this could be affected by the verdict form. In our approach, we would not be asking for the jury to allocate specific CUTPA damages. We would simply ask them to allocate emotional distress and reputational damages. So what I want to make clear for the record here, and I understand the defendants dispute this, is that in our view, all of those damages are CUTPA damages. Reputational harm and emotional distress. I don't think that has to be addressed in the charge here. I just want to make it clear on the record.
All right, so what is the next thing I need to address in the charge? Tell me what page. I'm now working off the same version you're working off.
Let's see, I think that would bring us to to suggested amount of damages.
Okay.
And I think we did talk about this briefly. You know, I prefer the standard charge. I don't know what.
I do too, so I don't see any reason to deviate from it.
Your Honor, we just feel that it's important that the jury know that all counsel can make those
Sure, I
arguments,
like
and
the
that's the
charge.
basis for the.
I don't think it's necessary.
Then, Your Honor, on the punitive damages charge, If you
What
look
page
at
are we on?
the plaintiff's,
35.
sorry.
35?
Yes, ma'am.
Okay.
35, yeah, is where it begins. I'm just not saying page numbers because I'm not sure which version everyone is looking at.
Okay.
If the court goes on to the plaintiff's proposed version, we had added the definition of willful, wanton, and malicious.
Well, that we needed to do. So
Yes, that needed
I
to be
agree.
done.
That
and-
was
We
not,
agreed to that.
And the defendants agreed, so
Yes.
we're done with that.
I had one objection, Judge, and that is because of the way this case lies, that is 3 common law counts and a statutory count, and the prospect for unlimited punitive damages in the statutory count, I object to the language that talking about punitive damages being limited to attorney's fees and expenses, because that will, I expect the plaintiffs to argue that Jones' conduct has caused such longstanding and ongoing harm that into the future these folks will need compensation, and thus we need an enormous sum of money. I'll argue otherwise, but I think telling the jury that punitive damages are limited leads them to believe that this is the only bite at the apple that any fact finder will get as to Jones, and might incline them to pack more damages into the compensatory than are warranted. And thus, I think they will be told that punitive damages are decided by the court, but it's misleading to tell them that punitive damages are limited to attorney's fees and expenses in this case, because they're not. And so I would recommend plaintiffs seek an award of punitive damages, and then punitive damages may be awarded if you find, and I would request that the limitation of the language saying limited to attorney's fees and expenses be excluded. I understand it's part of the standard charge, but the standard charge contemplates this count perhaps being charged in isolation. Given the law of the case as a whole, I think this misleads the jury about what they're going to be doing tomorrow or the next day.
First of all, it is the standard charge. Second of all, the jury should be entitled to know what the truth is, and what their award here will mean.
I agree.
Well, are they going to be told then that if juries are entitled to know what the truth is, are they going to be told the court will have the ability to assess punitive damages in an amount it finds in its discretion? Because that's the truth and the whole truth.
Well, Your Honor, what I meant was, and Attorney Pattis.
I mean the whole truth.
No, what I meant was the truth about the work that they are doing.
No,
You know, they are being charged to do this. They're entitled to know what it is. And they also, I mean, it is the standard charge. I think one of the reasons why it's the standard charge, and Attorney Pattis's argument, you know, if it were viable, would be in so many cases. I mean, it would be in any case where there's a cup account, and any case where there is an intentional tort. So I don't think that.
What would be the harm in that? What would be the harm in letting the jury know the truth? I mean, we're here on a default where with extreme limitations as a result of sanctions on what could be told. My client has frankly elected not to testify because he thinks that telling the truth exposes him to harm here.
So are you suggesting, Attorney Pattis, that the language after limited to attorney's fees and expenses, that the words at the court's discretion be included?
I'm suggesting they be eliminated, or in the alternative,
Well,
the jury be informed that the court may award punitive damages in an untethered amount or in its own discretion under the cut account in addition. Because what I'm concerned about is the jury thinking this is the only bite at the apple that a fact finder is going to get, and therefore we better load it up where we can in the soft money that isn't future economic harm.
Your Honor, the court pointed out how important it is to charge fair, just, and reasonable over and over again, and it has.
Right.
So
I
that
agree.
what-
So I'm going to leave that language in. I understand, Attorney Pattis, you'll take an exception. All right, next.
I think that's it.
That brings us to the end of this charge,
All
Your
right,
Honor.
then we have your filings.
We do.
And have you had any discussions with each other about them? or no?
Briefly, we have.
Very briefly, yes. So.
Just give me one moment, please.
And at some point, Judge, I need to take an exception to a charge not given. So I don't know when you want me to do that.
A charge that was requested and not
Yes,
given?
yes, Judge.
I suppose after I charge, right?
I can't remember. It's been a long time since I've tried a civil case. I usually just do criminal.
I'm sorry.
I usually take the exceptions after the charge, and then, if I missed a word or something, which I'm old.
Well, no, I mean, it's the substantive, it's the jury nullification charge.
Well, I think you take that after the charge is given. All right, so let me pull up the case and tell me which one, or do you have agreements on any of them, or no?
Don't think so.
Okay, so tell me which one you'd like to do first, please.
I think we could take them in order. This is docket number 1001, Your Honor.
So Attorney Pettis, I don't yet see your office having filed your motion for directed verdict. Just please make sure that they get it in today so I don't worry.
Yes,
Okay, thank you. 101.
I'll take care of that at the lunch break, Judge.
Yep, 1001, correct?
1001.
I have to get in, so. So we're taking up number 1 first.
Yes.
Defendants are responsible for worse damages due to plaintiff's vulnerability as grieving parents. So just 1 second, if you don't mind. This is like the eggshell plaintiff? Yeah.
Yes, it is. What we tried to do is adapt eggshell plaintiff to this circumstance.
Is there an eggshell plaintiff standard charge?
There is. It's 3.4-1. And it's a paragraph in 3.4-1, which is damages general.
All right, so just give me 1 second to get to 3.4. I'm just trying to find it. It's a long charge. Do you remember where it is? In their standard charge? Oh, I see. It's the last.
Yeah. I can get there, Judge. Give me 1 moment, and I'll pull up the standard as well.
Do you want me to just read the last 2 paragraphs? Attorney Pattis?
Yeah, I object on the following grounds. The plaintiffs, what the court is unaware of, the discovery was done. The plaintiffs, in some cases, had extensive counseling and psychological issues, some even predating the loss of their children. And the plaintiffs elected to produce none of that, to offer no testimony about their psychological state. And we, to avoid enraging the jury, given the court's rulings on causation, didn't address it either. We even reached certain accommodations as to one witness to cover this claim, where the plaintiffs agreed to ask a question so that we wouldn't be in the awkward position of putting a person on the spot. I think they're free to argue that, but I think given the evidence that they produced or didn't produce, they're trying to have their cake and eat it too. There was significant damage of alternative sources of harm and vulnerability in these plaintiffs that could have been produced. It wasn't. where it could have been challenged.
Your Honor, our client's medical records were produced extensively to Attorney Pattis.
And we're not claiming that they weren't.
Well,
To the contrary.
but the thing is, so Attorney Pattis had the ability to cross-examine on them if he chose. Our clients testified at length about their emotional state in relation to the deaths of their loved ones at Sandy Hook.
Well, the nice thing
and then
about the eggshell plaintiff charge is that it makes clear that you can't compensate plaintiffs for pre-existing. I mean, you could word it in a way to make
Our
it.
claim, Judge, is that notwithstanding the fact that many of these folks sought extensive psychological care, the plaintiffs chose not to put any of that evidence on, and now they seek the benefit of not having.
Yeah, I don't agree with that. I mean, there was extensive evidence about their emotional and mental health
But not
after
about treatment
the-
sought and other sources of harm. In fact, the court's causation ruling made it quite clear that I was limited in what I could do.
But there was abundance of evidence. There was some evidence about counseling.
There was, Your Honor.
Yes.
that we-
12 visits to an AEP person.
No, and then I could look through my notes. One of the recent witnesses also,
There was.
there was one witness that talked about counseling that they went to with their spouse, and then I thought there was another witness, but it's not
Right.
even,
So, for instance, here's the Soto girls, Bill Aldenberg. There's extensive evidence, if it turned on counseling, which it doesn't.
just give me 1 second, please.
This is the standard.
Well, this is a one-way street, the way that it's drafted. It doesn't make clear that they can't be compensated for their, original emotional distress that predated the wrongful conduct.
Oh, okay, Your Honor, so I'm looking at the standard here. So this is fine, right? And
I
then,
mean, the standard says you may not compensate the plaintiff for it says pre-existing injury itself.
right, so, Your Honor, may we have a moment, because there's a lot of whispering in my ear, it makes it hard for me to concentrate. This is the language in the standard. So, Your Honor, we think the standard would substitute appropriately here. The only thing is we'd have, we just want to adjust it the way we have been.
Just the first paragraph.
One moment.
So for example, you may not compensate the plaintiffs for
The loss of the suicide of Mr. Richmond, the suffering of their children, we could go on and on, the loss of their, the loss of their, the loss of the decedents. I mean, I think that they're free to argue that, we're both free to argue, I just don't think, I think it's a difficult
Yeah.
ticket to wade into here.
So the issue we're having, Judge, is the proximate cause language in here. And the way that it is, how we resolve that when causation is already addressed by the default.
Just give me 1 second, please.
Judge, if I could suggest that the charges were due in this case September 19th. This is a supplemental charge, untimely filed, foreseeable from the beginning of the case, and it's now beginning to take on a life of its own, and we're revisiting issues we've already addressed multiple times.
Yeah, I would say, Your Honor, if I may, sorry. We believe, I think that the truth here is that this issue has been resolved by the default, much the same as it's a proximate cause issue. I agree with Mr. Pattis's first comment on this, actually. I didn't realize the proximate cause was in here. This issue was resolved by the default. These plaintiff's damages that they presented in court are all related to the misconduct by the default of Mr. Jones. And so what this is an attempt, Mr. Pattis wants to attempt to bring in an alternate cause.
No, I didn't suggest.
Excuse me, Mr. Pattis. Mr. Pattis is trying to attempt to bring in an alternate cause of the plaintiff's emotional distress, which is foreclosed in this case, because that's an alternate cause of damages. That has already been decided. So, in other words, it would be improper for him to argue that the emotional distress that they're suffering isn't related to all of the evidence that we put on what the Jones has done through his conduct, but is related to the other things in their lives. And that's just not allowed, that ought not to be allowed in the default. That's bringing back in causation. Now, granted, the emotional distress has to start after Mr. Jones gets into the picture. Everybody agrees with that. So in other words, it would be equally, wrong to say that he's responsible for the emotional distress before he gets into the picture, which was about 3 hours after the shooting.
Because this is verging on incoherence. I'm objecting to their request to charge, and they're attributing motives to me for my objection to their request to charge. I understand what the law of the case is here. I don't think the charge is necessary. I think it's an effort to relitigate issues that are raised judicata, not just with respect to the law of the case, but in the charge as a whole.
What about language along the lines, I think this actually helps both sides and makes it clear. Something along the lines of, you may not compensate the plaintiffs for emotional distress, whatever you want to call it, suffered prior to the defendant's wrongful acts. However, if you find that a plaintiff was more susceptible to harm, the defendants are responsible for damages to an especially sensitive plaintiff. Something along those lines, so that we're making clear to them, you can't compensate the plaintiffs for their emotional distress related to the shooting, but
I think it's parsing a line that doesn't need to be parsed. I don't think the charge is necessary.
well, I know that you've made that clear, but I
I object to the proposal as well.
I think the court's proposal covers it appropriately.
I'll give it some thought.
And Your Honor, I didn't get exactly what the court said there.
It's not perfect, it's.
Understood,
it's-
understood. I
mean,
just wanted to,
Listen, the truth of the matter is that they can't compensate the plaintiffs for their unrelated emotional distress that they suffered as a result of losing their children prior to the defendant's wrongful acts, or their emotional distress related to losing their children. That is not, this is where it gets a little tricky.
It's tricky, and
So-
I would just say that's we're getting back to the raison d'etre of the eggshell skull in the first place, that at some point these things join, and they join 3 hours after.
I
the
hear you, but
shooting.
I just decided I'm not gonna give the charge, you're gonna deal with it in argument, and, if there is something occurs during the argument that's not copacetic, that's not accurate under the law, then I'll reconsider that, because, there's something to be said for making it clear to them. All right, so if somebody crosses the line or it needs clarification, then I'm gonna have to go
Can
there.
I speak to Attorney Koskoff for a moment?
Sure.
Thank you, Judge.
You're welcome. So number two, I did say earlier that I was going to address this, and I do think this is appropriate. I don't know that it needs to be so long.
Can you remind me what number 2 is?
About all the evidence that was elicited that I didn't say, that Mr. Jones, I didn't say their names, or I didn't say a name. That seemed to be a little confusing, I think. So I think that, and I did say earlier that I would
Yes.
address it in the final charge, so, but this is way too long.
Judge, we would object to it at all,
I-
because
yes.
as pled, the plaintiffs never referred to him as the sole cause, but as the primary cause. And that leaves open some brief wiggle room, and we believe that supplemental charge charges out that wiggle room and makes it appear as though Mr. Jones started it all for the world as a whole. And that's just not even what was pled, but that's how the case ended up being tried.
So I understand that, and your exception will be noted, but I like just the one sentence, the defendants are liable to the plaintiffs in this case, and it does not matter whether or not he singled them out by their individual names. And that's all
I think
that,
that's correct, as given the law of the case.
so that is, say again?
Without agreeing with the law of the case, I think that's consistent with the law of the case.
So I like that one sentence somewhere. Where would you propose that it go?
In the thank you note to the juror after they've returned the verdict. I don't take a position on that.
Attorney Sterling, what we just, we're.
Maybe on in the evidence section, you know, where you tell them about their duty to find the evidence and follow the law.
It seems to me it should go in the defamation charge, not the defamation damages charge,
Right,
but
so
the defamation charge.
Give us the proposal now so that we can see if Attorney Pattis can live with it. Why don't you just make it the second sentence?
The second sentence in the defamation charge.
Yeah, the court has determined that the defendants are liable for defamation. The defendants are liable for defamation, and it does not matter to their liability, whether they were singled out by their individual names.
That's elegant, we agree.
Okay, I mean, that makes sense.
That's fine, Judge, thank you.
Okay, next.
Okay.
Just bear with me. I don't see this.
I don't know which one you're on.
First Amendment, Second Amendment politics, when the lawsuit was filed.
Your Honor, I think we can pare this down significantly. So what we would ask is simply a line that says the first. Nothing.
Sorry.
Sorry.
Can we have a moment, Your Honor?
Sure.
Yeah, that's good.
So, Your Honor, thank you for your patience. The committee over here has decided that the only aspect of the charge that we want to stand on here is the piece regarding when the lawsuit was filed. It's at the
So
very
is
bottom
there
of the page.
The date, when the plaintiffs filed the lawsuit, Attorney Pattis.
I don't recall the language, but my sense is I think it's an inappropriate charge. The claim is that from 3 hours after the shooting, Jones caused them extensive harm. I think this jury is entitled to wonder, and may well wonder, why it took them 5 years to file the suit.
Well, I think that's where the injected politics was
Exactly,
coming
that's
into
why we
play.
need the
So
charge,
I
Judge.
think that it merits some clarification, so maybe just one sentence. You know,
May I just point one thing out, Judge? Based on what Attorney Pass just said, his argument, he said that Jones had made the statements within 3 hours, correct. He wants the jury to draw an inappropriate inference from that, and that's why that's why we
well, I'm
need
going
this
with the
charge.
sentence, so you don't need, what do you want me to change my mind?
Should I sit down then?
Yeah.
Thank you, Judge.
The date on which the plaintiffs filed the case is irrelevant to your considerations, and you should not consider that in any way in determining the damages on this case. I don't see how it is relevant or how they should consider it, so there's nothing wrong with that sentence.
We take an exception.
I understand.
So then the only question, Your Honor, is where does that go? It strikes me that that ought to just be its own standalone. I'm not sure where it would go.
Maybe after causes of action and before intentional infliction of emotional distress.
That makes sense.
Oh, Ron, can I see you for a second? I want to go after 1, but I don't want you to stay because it's been a long day. So I think we're probably going to go like another 1:15 or so because I want to get done for the day.
She's saying it's fine to
I'm
stay.
not asking, I don't want, thank you anyway, it's too much. All right, so missing videos, what's this? Number 4?
Yeah, and Your Honor, on this one, there's also, we thought that this needed some support from the record, so that there's a motion in support of this charge and a revised proposed charge in that motion. That's docket number,
So can we skip this and then get?
let's skip this.
Okay.
And then the very last one in here is the charge on playback of videotape depositions, which the court's already given and does not need to give again.
Okay,
So
so
that
let's-
takes us to the end of this.
Sure, so what's the next document we're looking at? And my plan here, I want to finish and then adjourn for the day, just so
Okay.
you know, so we're gonna. not-
Right. So I
Smart.
think
You
the
agree with that
next,
decision, Attorney Pattis?
I agree, Judge.
yeah,
All right, so the next one,
taking them in order, the next one would be life expectancy. That's docket number 1005. And we, yes.
So I think, at sidebar, I suggested all the factors in 3.410 be charged. Having had a chance to read through it, I would agree that that the first, second, fourth, and fifth can be eliminated.
First, second, fourth, and fifth of the list.
Yeah.
Yeah, that's what I was struggling with the lead in here under the facts of this case, but
do you want to just
Why don't
talk to
we see
each
if we can
other
work something
real
out?
quick and see if you can efficiently do it that way? Thank you.
yeah, that's what we went.
You should consider probably that they're
Oh, no, before you get to that, you have to have a lead in.
That's my opinion.
But this says if you award damages, and we know they're awarding damages, so.
Well, we don't. We don't know that they're going to do more than nominal. In your award of damages, you should consider.
Oh, here,
Proposing that, I'm proposing
I
that.
hope you're not offended that I didn't ask you to stay late, but here's the thing, I don't like to do that because no one ever.
As a courtesy
And then
to you,
because I feel
I'm avoiding
guilty, I
saying if any.
can say no, and that's why I just don't
Your
like
award of damages, you should consider.
be pushy or imposed, do you know what I mean? Because how hard would it be? I understand, I tell Ron all the time, people have lives, they have lunch plans, that's. Well, maybe you would, but like, some people would never, even if it was a problem, so that's why I always like have the policy, don't do it.
So what are your things, sir?
Thank you,
But if,
okay.
in your award of damages, you should, when you.
All right, did you
well,
work
this
it out?
This should come on the heels, of the, we're just trying to line this up, Judge, with
Okay,
the part of the charge where the court instructs on future damages.
okay.
So once we find that part, I think we can bridge it to
Yeah.
this.
Your Honor, I wanted to point out, just because we have not yet addressed verdict forms, and I think that is an area where we're not very far.
Okay, let's finish the charge first and then figure out when we're
Okay,
gonna do
I
that.
just wanted to alert the court because I was concerned about
Okay,
lunch and staff.
all right, well, we're gonna get through the
Timing.
charge before we take our lunch break.
So what we want to do
Or starve?
What do you,
I just
want
need
to
to-
work that out with?
No, it's already worked out.
Okay,
But we just need to, I just need to see if it lines up, because it needs to be
Okay.
rich.
okay. So,
In your work for future damages, we should say.
If you award future.
No, she's.
so it's gonna go, I think it would go after cut off, and before suggested
No, but
amount
I
of
thought-
damages.
Where is the, I just want to, what does the court have, what will the court have charged on future damages?
It will have charged, in a couple different places, so.
just trying to, we have to see if it works with the language in terms of future damages.
Miss Ellis can come in, but she'll have to shut down and she'll have to restart. That might take 5 to 10 minutes.
Well, we'll go to one. Yeah.
That's no point.
Sure.
We have a different court reporter starting at 2. That's why she doesn't mind staying the 15 minutes.
In your consideration of damages, in my view,
I think you just have to say future.
you should consider
I may do
Yeah.
the
probable
afternoon,
length of the plaintiff's
like
life.
3 o'clock or something, and do it remotely. And do the,
Yeah.
verdict.
Might make it at least open.
Consider that. Fellow Scriveners, highest respect, adopting your language.
Right, so how does it work then?
But that's what we just have to see if it works with the language.
This is the damages compensatory charge. Comes before.
No, because I think there may not be much left, and we may just end and then do the
Defamation damages.
verdict form.
And
Let me see.
she charges.
Let me ask. Can I interrupt you for a second? I'm just trying to figure out what to do with the court reporters, if I'm having someone sub in or not. After this, putting aside the verdict forms, how many more issues do we have?
We have, unless I'm missing, we have the missing evidence charge. We have verdict form, Attorney Pattis had proposed interrogatories. And I think that's it for charge and motion issues.
All right, so once we do the interrogatories and verdict form, we'll do after lunch. So you'll talk about this, then we have one more issue on the charge.
Yes.
Okay, so that's good, so we don't have to switch, I guess we might end on time at the rate we're going.
I think we do that, see, I think the bridge, that's one, submit the, I think that the bridge, because it's gonna come out on its own right now, is she gonna plot this right in to here, is that where it's gonna show that one?
So.
Should they, should
I
they,
would,
we know we should do it there.
here, it could go there, or.
I think you just have to put the word future, because it has no bearing on present. I mean, it's obvious, but or fees, so it would read, so just look how it would read, it just needs, I think, in your consideration of these future damages. And it's not even like a,
Yeah, okay, because of that, because of the use of the word future there. So my
and then
proposal
these
would
maybe
be, in your consideration of future damages, you should consider the probable length